Okay, welcome everybody to the Professional Development webinar series from SLIS. This is our fourth installment this year. A few housekeeping notes before we get started. Please use the chat area to post any technical difficulty questions and the Q&A area to post any questions for the speaker for the end of the webinar. Finally, there will be a short 5-minute break halfway through today's webinar. Benson, can you advance the slide a couple bits?
Absolutely.
Oh, actually one more.
There we go.
That's fine. Okay, today's speaker, Benson Green, is a trial consultant specializing in high-stakes intellectual property litigation, whose primary focus is on patent litigation in the pharmaceutical, medical device, computing, and cell phone industries. In addition to his extensive patent litigation experience, Benson has worked on copyright and trademark litigation across a wide variety of industries, including food and beverage, hospitality, and automotive manufacturing, as well as cases involving the fine arts, film, and tabletop gaming. Benson has also provided thousands of hours of pro bono services to artists in partnership with organizations such as Lawyers for the Creative Arts, which provide legal services to creators who may not be in a position to afford market rate legal services. So please join me in welcoming Mr. Green.
Hello, everybody. I guess we'll go ahead and get started. Thank you, Ed, for that introduction. I seem a little bit distracted. It's because I'm on the road. I'm in a hotel room right now. I'm actually at a trial, or at least I'm doing trial prep right now. The jury selection's on Monday, so this is going on in the middle of a lot of stuff. But today we're going to be talking about copyright for specifically with regard to digital materials. But I wanted to make sure that we covered the basics of copyright law first, and especially the concept of fair use. When we talk about some of the cases we're going to talk about today, a lot of them involve fair use analyses. So first of all, a little bit more background about me. As Ed said, I'm a trial consultant. Importantly, that means I didn't go to law school. I'm not a lawyer. I don't have a law degree, and I'm not admitted to the bar anywhere. So, of course, nothing that I say here in this webinar should be taken as legal advice of any kind. Okay. So now that that's out of the way, I'm not going to get in trouble. What is trial consulting, and why do I know what I do about copyright law? Well, simply put, trial consultants help attorneys prepare their cases for trial. So this may seem a bit redundant because you would think that lawyers already know how to handle trials. But a funny thing happens to people when they go to law school. They stop thinking like regular people and start thinking like lawyers. My job is to help lawyers remember how to talk to regular human beings. I specialize in understanding how people process information, make decisions, and behave as a group. And one of the ways that I do that is by conducting small group research projects, such as focus groups or mock trials, to see how jurors are going to react to various issues in the case. I help lawyers pick juries. Yes, and a lot of people think that's what most of the trial consultants do. But a more important part of my job, and it's related to why I know what I do about the law, is that I develop overall case strategy, identify key trial themes, and I help prepare witnesses for testimony. I draft opening statements and closing arguments. And so because of that, I have to know what arguments can be made and are allowed to be made in a courtroom setting, so that way, nobody gets in trouble. We don't violate any rules of evidence, and so that's why I kind of know what I do about copyright law. In terms of the kind of cases I work on, my experience is almost exclusively in intellectual property litigation. I've done plenty of work in product liability, contracts, torts, employment law, and so forth. But the bulk of my experience is in intellectual property litigation and predominantly in patent litigation, because that's honestly where the money is. There's not a lot of money in copyright and trademark litigation, and there's a few reasons for that. Copyright cases are less likely to go to trial, mostly because they are inherently unpredictable. Copyright law, as you'll probably discover through our discussion today, is very subjective, and because of that, it's very hard to predict what jurors are going to do in a copyright case. So there's a lot of uncertainty with regard to it. Additionally, because it's very subjective, judges don't like to dismiss copyright cases very often because there's a lot of fact-specific issues that a jury is going to have to decide, and the judges don't want to make those decisions. So if you have a copyright infringement case, you're almost guaranteed to have to go to trial on it, and you don't know what the jury is going to do, or at least it's harder to predict what the jury is going to do at trial. And so for that reason, a lot of copyright cases settle out of court. Another reason why copyright cases don't go to trial is often the injured party is a starving artist who either can't afford a lawyer, or it's just not worth it to try to pay a lawyer to try to deal with the situation. And so a lot of my work, as Ed mentioned at the beginning of this, a lot of my work in copyright cases and trademark cases has been pro bono. So while I often don't get paid for my work on copyright cases, I'm usually involved very early in the process, sometimes before the client even has formal legal counsel. And I tend to work very closely with both the lawyers and the clients throughout the entire process. So as you might expect, I'm very passionate about copyright law. I put a lot of time into understanding how it works. And I've probably done about 5,000 or 6,000 hours on copyright cases over the years. And now my experience in copyright cases is pretty wide ranging. It involves anything from fine art to toy soldiers, board games, independent films, and Pepe the Frog. So I've been involved in 2 copyright cases that have been tried to verdict. A lot of the other ones settle out, because even the pro bono ones wind up settling out. But I have been involved in 2 copyright cases that have been tried to verdict. So that's my background in copyright law. Again, I'm not a lawyer, but I have a lot of practical hands-on experience with how copyright law works and the various things that go into the standards of evidence and whatnot for that. And I've done a lot of independent research on copyright law. All right, well, first let's get into copyright basics. What is a copyright? Where does copyright come from? I find that the best thing when dealing with any set of laws is to understand the purpose the law is intended to serve. Because a lot of times the way courts will interpret the law is consistent with what the idea is, right? So a lot of times you think that laws are really persnickety and it's about what it says exactly, but in reality, laws are very often interpreted based on the spirit of the rules and not necessarily the exactness of the rules. So where does copyright come from? At its most basic level, copyright is intended to promote artistic expression. That is, the creation of art in whatever form that takes is recognized as an important part of human culture and a valuable contribution to society. So in other words, as a society, we want more artists to make more works of art, and copyright is intended to encourage the creation of artistic works in the same way that patents are intended to promote artistic expression. And so as you can see here, copyright protection in the United States stems right from the United States Constitution, Article 1, Section 8, which covers both patents and copyrights. But it says to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's where copyright law comes from. That's the point of it. In other words, copyright promotes the creation of artistic expression by doing 2 things. First, giving artists the exclusive rights to their artistic expressions helps to ensure that artists are able to profit from creating art. So why would you create a work of art if someone could just copy it and compete with you in the market for it, right? So it gives you a financial incentive to create works of art by protecting your ability to make money off of it. Second, limiting the duration of exclusivity is very important because it encourages artists to make new works of art because your protection will expire. Although functionally now protection is the life of the author plus some amount of time. But more importantly, it allows artists to build upon the works of other artists after their rights expire. So artistic expression thrives on inspiration, adaptation, recasting, repurposing, reusing, and reimagining the works of other artists. And so limiting the duration of exclusivity is an important part of copyright law. For example, the British Library, which has released millions of digital materials into the public domain, has explicitly done so in part to encourage artists to find new ways to use those works, including for commercial purposes. And so if you take a look at a quote from their website, the British Library says that their collections on Flickr Commons offer access to millions of public domain images, which we encourage you to explore and reuse. The release of these collections into the public domain represent the library's desire to improve knowledge of and about them, and to enable novel and unexpected ways of using them, which is important, and to begin working with researchers to explore and interpret large-scale digital collections. So this really is the point of copyright laws, are to give artists the ability to expand upon the works of others. So exclusivity is really important. All right, but what are the nuts and bolts of copyright? We're not going to get too deeply into it today, and we talked a lot of it. We did a deep dive into it in the last webinar, but I want to pop the hood on copyright law just a little bit and take a look at what it is. So we can start by examining the word itself, copyright. It's a compound word, copy, right. It's the right to prevent others from copying. That is copyright law in a nutshell. But to get more specific, let's take a look at the list of exclusive rights that the law grants to the holder of a copyright. In the US, the owner of a copyright has a list of exclusive rights, and there's important limitations, but here are the list of exclusive rights. Now, I have it on this. I have it on this side here, the left side. It's really small, but what that is saying in basic is you have the right to reproduce your work, distribute it, display it, and perform it. Those are exclusive to the creator of the work. In other words, you have the exclusive right to make a copy of your work and to control it and to control if and how the work is distributed and consumed, which are basically all the ways an artist might make money off of work of art. You can also sell, lease, license, or otherwise transfer your ownership of the copyright itself, right? So if you do a work for hire, for example, the company that hires you is going to own the copyright because you're going to transfer the rights to that work that you're creating for hire. If you write a novel, you can transfer the rights to that to somebody else, either part of them, or all of them, or you can inject it into the public domain deliberately. Okay, so if copyright protects against copying, what does it protect against copying? So copying of what? For that, we'll take a look at US 17-102A, which is another big wall of text. But the three important bits to get out of this, and that's the actual statute in the US, but the three important bits to get out of this are original, fixed, and tangible. Those describe, those concepts describe the boundaries of a copyright. So in order to be protectable, a work must be an original work of authorship, fixed in a tangible medium of expression. In other words, if it is itself a copy of something someone else did, or of the work within the public domain, it is not protectable. And to the extent that an element of a work is such, it is also not protectable. So the work as a whole might be protectable, but if you copied an element from something else, that element itself is not considered to be part of the protectable scope of the work. Further, concepts and ideas are not protected by copyright. Section 102B is a very important section of copyright, and it says, in no case does copyright for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. In no case, to any, regardless. It's very strong language, and really what this is saying is that there's a wall between a copyright and a patent. right? Remember the Constitution kind of bundles those two together to promote the progress of science and useful arts. But Section 102B really puts a hard line between what is subject of copyright and what is the subject of a patent. And essentially the difference is art versus a useful article, right? A patent has to be something that's useful, either a thing or a method that is that serves a useful function, which could be a process, a procedure, a system, a method, right? Or even a discovery. Whereas a work of art has to be something that's essentially valued only for its artistic qualities, right? So clothing, for example, is exempted from almost entirely from copyright protection because clothes are useful articles, even though they might be artistic. The fact that the design and structure of a garment is primarily functional carves it out of copyright protection almost entirely. Okay, now these limitations exist because overly broad copyright protection, just like overly broad patent protection and trademark protection, subverts the very purpose of copyright laws. If copyright protection covers an idea, for example, it restricts the creation of new works of art. If patent protection is overly broad, it prevents others from building upon the work of other inventors. I like to say that intellectual property is not intellectual because it only exists in your mind. It is intellectual because it is the product of your intellect. And that's really what fixed and intangible expression means. Copyright can't cover something that you wish or imagine or desire or what somebody else has already done. It is what you do that's unique, that you actually create in the world, right? And you fix it in some kind of tangible medium of expression. Copy in this context is specifically relegated, as I said, to the realm of works, fixed and tangible medium of expression. It's in the realm of things and not the realm of ideas. Now, before we go on to the various statutes that are related to digital work specifically, I want to talk about the concept of copyright fair use. So this is the basics of how copyright works. It gives you the right to control copies of a work of art. It's only the boundaries of it are only what you did that's unique compared to what everyone else has already done, and you have to fix it in a tangible medium of expression. And if your exclusivity is a limited period of time. But there are carve-outs for liability. So if you copy something and somebody else did, you're liable for copyright infringement. But there's an important carve-out for liability called copyright fair use. And like I said, fair use is very important when it comes to digital work. So I want to walk you through the concept of copyright fair use now. Okay, so this is the Section 107 of the U.S. Code, fair use exemption. Basically, what this says is that notwithstanding the provisions earlier, you can escape liability if your use falls into certain categories. And the way that the law says you determine fair use is by examining 4 different factors: the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit or educational purposes. Again, a commercial use, much less likely to be fair than a nonprofit educational use. The nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, so how much did you take? And the effect, and this is important, technically none of them are supposed to be more important than the others, but number 1 and number 4 tend to be more important to judges. Number 4 is the effect of the use upon the potential market for or value of the copyrighted work. We'll talk a little bit more about that in a second, but again, remember that copyright is intended to allow artists to make money off their works of art. And so if you are making it more difficult for the owner of a copyright to profit off that work, it cuts strongly against fair use because it subverts the very purpose of the law itself. As a matter of policy, Fair use is based on the belief that the public is entitled to freely use portions of copyrighted materials for purposes of criticism or commentary. The fair use privilege is perhaps the most significant limitation on a copyright owner's exclusive rights. So if your use is fair, you can't be held liable for infringement, even if you infringe upon their rights. All right, so what is normally considered to be fair use? I think my next, so typical fair use criticism, typical fair use cases, and this comes from what has typically been found by courts to constitute fair use. First is criticism and commentary. For example, quoting or excerpting a work in a review or criticism for purposes of illustration or comment is normally fair use. For example, a book reviewer would be permitted to quote passages from a book or newspaper column as a part of an examination of the book. News reporting. Summarizing an address or article with brief quotations in a news report typically constitutes fair use. For example, a journalist would be permitted to quote from a politician's speech without that politician's permission. Research and scholarship, it's a big one. Quoting a short passage in a scholarly or scientific or technical work for illustration or clarification of the author's observations would normally be deemed fair use. So for example, an art historian would be able to use an image of a painting in an academic article that analyzes the painting without getting permission. Nonprofit educational uses, very important for schools and libraries. When teachers photocopy, for example, limited portions of works for classroom use, that's normally considered to be fair. So for example, an English teacher would be permitted usually to copy a few pages of a book to show to the class as part of a lesson plan. Note, however, that that teacher would usually not be permitted to photocopy the entire book, right? That goes to amount and substantiality of the portion taken. Parody, again, it's similar to commentary and criticism because parody really is commentary and criticism. A parody is a work that ridicules another usually well-known work by imitating it in a comedic way. And importantly, fair use parody requires that the use of the work be indispensable to the criticism. So you usually have to be making a comment about the source of a trademark or a copyright. It's less protectable to use a different work to make fun of something else, because there's a question of, did you have to do it, right? Could you have done this commentary or criticism or made this joke in a different way that was non-infringing? And if so, it's less likely to be covered by fair use. All right, so like I said, there's several factors that courts will consider when determining whether an instance of infringement qualifies as fair use. And again, it's important to note that before you even get to fair use, you have to have liability. So fair use only kicks in once you are already liable for copyright infringement. So if you have infringed the copyright, fair use is kind of like a get out of jail free card. All right, so there's 4 basic considerations. Number 1, like I said, the purpose and character of the use. The big question here is, are you creating something new or just copying? Again, remember why copyright exists. We want to promote the creation of new works of art. And so if you're engaging in transformative work, right? If you're taking something and turning it into something new, that weighs in favor of fair use, because the point of copyright is to promote the creation of new works of art. And then a related question is whether use is for profit or nonprofit use. It's kind of related to some other of the fair use factors, but that can also be considered as part of the purpose and character of the use, depending on what court you're in and who's on the bench. Next one is the nature of the copyrighted work. The big question here is, are you taking something factual or something creative? Now, the reason why this is important is because facts are not protectable by copyright, right? Because copyright only covers things that are creative and artistic. So a bare bones fact is not protectable by copyright because there's no creative effort on part of that. So if you're copying something that's entirely factual, that weighs in favor of fair use versus something that's entirely creative. The next one is the amount and substantiality. This is pretty basic. Are you taking too much, or are you taking just what you need, right? So the idea behind this is if the teacher only needs to copy a few pages to make the point for the lesson plan, but she gave everybody a copy of the entire book, she didn't need to do that, right? And amount of substantiality also goes to the what is the most important bits, right? So an example is that if you might have a 500-page book, but there's some really juicy stuff, like it's a biography, but there's some really juicy stuff in there, and you copy the most important juicy stuff that no one knew before, that could be considered weighing against a fair use finding. Probably because it's intimately related to this next factor, effect upon the market, right? Are you competing with the source you're copying from? That's the main question there. So if you take the juiciest part of a tell-all biography and you publish that, right, it might have a significant impact on the sales, because now no one's going to buy that book because they already got the good stuff, right? So even though you might have taken just a small part, if you took an important part, especially if it's important with respect to the ability of the artist to make money off that work, that's going to be more problematic. So these are all the fair use factors. And like I said, we're gonna talk about legislation and lawsuits here in a bit after a short break. But almost every lawsuit that I'm going to talk about involves discussion of the fair use factors. So let me go ahead and take a break now. It's 1:30. We're going to take a break now and come back in 5 minutes, and we'll start getting into some legislation and lawsuits.
Also, just as a reminder, if you do have any questions that you would like addressed during our Q&A, feel free to put them in the Q&A section, which is next to the chat area. Okay, I'm going to disappear again.
All right, so now we've learned a little bit about copyright law and how it works. Let's talk about some relevant legislation that's particularly important with respect to digital works. We're talking about two pieces of legislation today. The first is the Berne Convention for the Protection of Literary and Artistic Works. The Berne Convention is an international agreement governing copyright, which was first accepted in Bern, Switzerland in 1886. The United States, however, did not join the Berne Convention until March 1st, 1989. And joining the Berne Convention involved changing a lot of United States copyright laws and how it worked, because it had to be sort of updated to meet the requirements of the Berne Convention. So the Berne Convention, formally mandated several aspects of modern copyright law. For example, it introduced the concept that copyright exists the moment a work is fixed in a tangible medium of expression, rather than requiring registration, which is something we've kind of already talked a little bit about. More importantly, with respect to digital works, the Berne Convention also enforces a requirement that countries recognize copyrights held by citizens of all parties to the convention. It's important for digital works because in today's age, somebody in Germany can make something and distribute it all across the world to be consumed by people in lots of different countries immediately, basically. So all member countries have to respect the copyrights of nationals from other member countries. The Berne Convention requires its parties to treat copyright works of authors from other parties to the convention at least as well as those of its own nationals. So, for example, French copyright law applies to anything published, distributed, performed, or in any other way accessible in France, regardless of where it was originally created, if the country of origin of that work is a signatory to the agreement. In addition to establishing a system for equal treatment that harmonized copyright amongst its parties, the agreement also required member states to provide strong minimum standards for copyright law, and that's again why the United States copyright law changed a bunch in preparation for joining the Berne Convention, because we did a lot of things that we didn't do a lot of things that the Berne Convention requires. Copyright term, for example, had to be extended to the life of the author. We had a much shorter copyright term before that. So before the Berne Convention, copyright legislation remained uncoordinated at an international level. So for example, a work published in Great Britain by a British national would be covered by copyright law there in Britain, but it could have been copied and sold by someone in France without any legal problems. So there's two big takeaways about the Berne Convention you should keep in mind. The first is that the Berne Convention means that copyright laws are pretty similar across member states, and member states must respect each other's copyright laws. The second big takeaway about the Berne Convention is that it wasn't written with digital works in mind, and it has not been substantively updated since the 1970s. The vast number of the signatory countries, plus their very different development levels, makes it extremely difficult to update the Berne Convention to better reflect the modern conditions. Additionally, another factor that complicates updating the Berne Convention is that it's hard to get out of the Berne Convention because it's a requirement for being a member of the World Trade Organization. So you can't just it's not like the Paris Climate Agreement. You can't just say, screw it, we're gone, because you have to be in the Berne Convention if you're going to be in the World Trade Organization. Now, one way for member states to kind of modernize copyright law is through the so-called front door. So instead of trying to modify the Berne Convention for everybody, one thing that nations can do is kind of is change their own laws and tighten up their own laws, which other countries are going to have to respect. So that can happen. And one of the things we're going to talk about that's even more important than the Berne Convention is a way the United States attempted to address digital works in a piece of legislation called the Digital Millennium Copyright Act, or the DMCA, which is probably one of the most important pieces of legislation related to digital works in the United States. All right, so let's talk about the DMCA and all of its warts. Okay, so the DMCA was passed in 1998 as an anti-piracy statute, effectively making it illegal to circumvent copyright protections designed to prevent pirates from duplicating digital copyrighted works and selling or freely distributing them. The DMCA also makes it illegal to manufacture or distribute tools or techniques for circumventing copy controls. In practice, however, the DMCA's effects have been much broader by allowing game developers, music and film companies, and others to keep a tight control over how consumers use their copyrighted works, preventing them in some cases from making copies of their own purchased products for their own use, or even from doing things like jailbreaking smartphones and using them in ways that the manufacturers don't like. The DMCA has two problematic and controversial sections because it's actually a kind of a conglomerate of like 5 different acts that are kind of bundled together and called the DMCA. But it's got 2 really problematic sections that are highly controversial today. Section 1201 and Section 512. Section 1201, which deals with the circumvention of copy protections, and Section 512, which allows the copyright holder to send a so-called takedown notice to websites and others believed to be infringing a copyright. Both have been abused by companies for purposes unrelated to copyright protection, which is problematic, which has led civil liberties groups and others to call for reform of the laws to clarify its scope. And some of the litigation we're going to be talking about today is about the DMCA and whether it's constitutional or how it should be applied or how it should be interpreted. Congress ostensibly passed the anti-circumvention provisions of the DMCA to discourage quote unquote pirates from defeating digital rights management functionality and other content access or copy restrictions on copyrighted works, and to ban the so-called black box devices intended to be used for that purpose. However, in practice, DMCA anti-circumvention provisions have done little to stop internet piracy, as I'm sure you're probably aware of. Yet, the DMCA has become a serious threat that jeopardizes fair use, which we talked about before. It impedes competition and innovation potentially, and it can have a chilling effect on free expression and scientific research in particular. For example, if you circumvent DRM locks for a non-infringing fair use, such as making a backup copy for your library, right? You've got a DVD, you want to make a backup copy of it. If you circumvent the DRM features on that DVD, you could be liable for infringement. So one of the problems with the DRM provisions is that there are legitimate fair use reasons to disable DRM functionality, but the law does not, the DMCA does not distinguish between those various uses. The safe harbor provision is also particularly problematic. I personally don't like it, so I'm a little biased about it. But DMCA safe harbor provisions are designed to protect service providers from monetary liability based on the allegedly infringing activities of third parties. Importantly, to receive these safe harbor protections, service providers must comply with the conditions set forth in 512, including the notice and takedown procedures that give copyright holders quick and easy way to disable access to allegedly infringing content. In other words, if I'm a copyright holder or alleged copyright holder, a lot of times it's alleged, but if I'm an alleged copyright holder and I see something on YouTube that I think violates a copyright, I send a notice to YouTube. And if YouTube immediately takes down the content, they are insulated from liability, right? They cannot be held liable. They can't be sued. They won't have to pay monetary damages. If they don't take it down, they don't get those safe harbor protections. So as you can guess, there's a very strong incentive to just say, fine, I'm taking it down. Get your safe harbor, and then let the person who put the content up deal with the fallout. And that's kind of problematic. The Section 512 also contains provisions to challenge improper takedowns, but they can be very complicated and difficult to navigate. And it also involves burden shifting, which is a problem. We're going to talk a lot about the Electronic Frontier Foundation today. The Electronic Frontier Foundation argues that without these protections, without these takedown protections and the safe harbor provisions, the risk of potential copyright liability, the EFF argues, would prevent many online intermediaries from providing services such as hosting and transmitting user-generated content. So we might not have a YouTube without these safe harbor provisions, the EFF says. So in other words, the EFF is arguing that safe harbors, while they are imperfect, while the EFF does recognize that safe harbors are imperfect, they have been essential to the growth of the internet as an engine for innovation and free expression. So there's a little bit of good, there's a little bit of bad. However, as I said, safe harbor provisions lean heavily in favor of the copyright holder. And this is something that the American Library Association argues as well. Safe harbor provisions give a lot of power to the copyright holder, or even alleged copyright holder, working in effect to reverse the burden of proof by requiring those accused of infringement to prove a negative, instead of requiring the person who's doing the accusing to prove their case, right? So if I'm accused of uploading some content that violates a copyright, I have to affirmatively prove that I did not violate a copyright, as opposed to the person who's accusing me coming with their own proof saying I did. So for takedown notice, really doesn't require anything. You can just say, yeah, that's infringing. And most content providers will just take it down because they want that safe harbor protection, because they don't want to be held liable later on down the road if they make a mistake and that content actually is infringing. They'll lose those protections, and they are the ones that have the money, right? So they're the ones that have the target on their backs. So it does wind up unintentionally, I think, leaning very, very heavily in favor of the copyright holder. Additionally, like I said, given the complexity of responding to DMCA takedown orders and the strong incentives for service providers to comply with them, safe harbor provisions can be rife with abuse. So for example, a 2016 study by researchers at UC Berkeley and Columbia University found that about a third of DMCA takedown notices are on shaky legal ground. And that was based on sampling of 108 million takedown notices over a 6-month period. It's very, very likely that a takedown notice is spurious, because it's easy to make a baseless takedown notice, and there are very few consequences for doing that. So not surprisingly, the American Library Association believes that although the DMCA expanded some protections for libraries, in the American Library Association's words, the DMCA continues to be a controversial act with far-reaching impact that is supporting the attempts of copyright holders to control access to and downstream use of their content. The doctrine of fair use has never been more threatened than it is now. That's the American Libraries Association's kind of stance on the DMCA. And the American Library Association is very cognizant of fair use issues because libraries in particular have substantial carve-outs in fair use. So a lot of the activities that libraries do are specifically called out as fair use. And the DMCA potentially challenges that because it doesn't take into consideration, technically, it doesn't take into consideration those fair use factors. It just says, if you do it, if you violate the provisions of the DMCA, you could be liable regardless of fair use or not. All right, so now we talked about that. Let's get into some litigation, and we'll see how some of these issues have played out in the courts. The first case we're going to talk about is Universal v. Reimers. I think that's how it's pronounced. I looked, I couldn't really find a pronunciation. I think it's Reimers. So Universal v. Reimers, or it's Universal City Studios Incorporated v. Reimers, the so-called DVD case. It was the first significant challenge of the DMCA. It was filed on January 4th, 2000. 8 different movie studios sued Sean Reimers, Roman Kazan, and a guy named Eric Corley, who was a publisher of a magazine called The Hacker Quarterly. They sued them over distribution of a program called DCSS. It was designed to be capable of decrypting the content scramble system. So content scramble system, CSS, DCSS, it gets rid of the CSS, right? CSS, the content scramble system, is a system that prevents you from just downloading the digital video on a DVD. It's a DVD protection. Hence the DVD case and why the film studios were upset about it. The defendants sought to invalidate the DMCA on constitutional grounds, but unfortunately the trial judge found in favor of the plaintiffs and the constitutionality of the DMCA, opining that although the defendants, quote, raised a legitimate concern about the possible impact on traditional fair use of access control measures in the digital era, Congress has nevertheless passed the DMCA, which the court says applied to the defendant's conduct of providing access to a DRM circumvention mechanism. So the trial judge said, that's it. Congress passed the DMCA. I'm not getting into it. Your conduct falls under DMCA. You're liable. Now, the case was appealed, and when it was appealed, it attracted 15 amicus briefs. That's when people who aren't parties to the dispute write in and say, I have an opinion about this. This is what I think. You should take my opinion under advisement because I'm important. Along with the ACLU and the EFF, the American Library Association co-authored an amicus brief in favor of the defendants, arguing that the DMCA, quote, represents an unprecedented expansion of copyright law. The ALA went on to argue that courts have imposed indirect liability for copyright infringement in situations in which third parties have knowingly and materially participated in illegal behavior. That's indirect liability. If indirect liability is expanded, again, the DMCA talks a lot about indirect liability. So I haven't infringed necessarily, but I'm doing something that's related to infringement, right? If indirect liability is expanded without regard to, one, whether there were any underlying acts of infringement. So if no infringement occurred, how can you be indirectly liable for infringement? 2, whether any relationship exists between the actual infringers and the person the plaintiff seeks to hold indirectly liable, right? If I'm not directing the actions of the person who's liable, how am I indirectly liable, right? Because usually there has to be a nexus between what I'm doing. I have to have some kind of control over the person. So I might not have fired the gun, right? But I gave you the gun loaded and I held the guy still, right? That's indirect, right? And 3, most importantly, whether a fair use or other free speech right applies, that expansion represents grave constitutional problems. So the Library Association is saying is that, most importantly, is that the DMCA doesn't care whether there was a fair use or not, and that's a huge problem. So the ALA went on to say later that This expansion clearly implicates the First Amendment. The anti-circumvention provision of the DMCA prohibits unauthorized access to all speech protected by access control technology, regardless of whether the user has a free speech right to use the speech. The anti-trafficking provision further inhibits access to non-infringing speech by outlawing the technology needed to obtain that speech. And to the extent that the challenge circumvention technology is software, that work is itself free speech, which is true. Software is generally considered to be free speech. The appellate court, unfortunately, in this case, affirmed the lower court's ruling and punted the ball on the fair use defense. The lower court opined, the appellate court opined that the DMCA's effect on fair use was beyond the scope of the case because the defendants had not themselves claimed to be engaging in fair use, right? So this issue kind of got, the can got kicked down the road with this case. And in particular, one thing the appellate court noted is that the appellants do not claim to be making fair use of any copyrighted materials, and nothing in the injunction prohibits them from making such fair use. They are barred from trafficking in a decryption code that enables unauthorized access to copyrighted materials. They said, we're not going to talk about fair use now. It's not an issue in this case. And another thing that the court said is they can still make a copy of the DVD. It's just not going to be an important copy. So they still have their rights. They're just complaining about not being able to have a high fidelity digital copy of the movie. They can point a video, they can point a camcorder at the screen or a microphone and still record it, right? So unfortunately, that was the result in in Universal Studios v. Reimers. The next case we're going to look at is called Perfect 10 v. Google. It's a little more interesting. Perfect 10 v. Google was filed on November 19th, 2004. Perfect 10, an adult entertainment magazine, sued Google for copyright infringement because a number of independent third-party websites hosted images from Perfect 10's subscription-only website. Obviously, those are pornographic images. As part of its image search service, Google provides thumbnail copies of images that are being searched for so the user can see them before accessing the website. I mean, you've used Google search before probably, so you understand how it works. At the time, it was new. And when a user selects an image from Google search, a new page is accessed that includes the original website, as well as a frame that contains information about the image and the thumbnail version of the image. Now, importantly, Google did not store or physically transmit the full images, only the thumbnails. Perfect 10 alleged both direct and indirect infringement. So they said the thumbnail creation itself was direct infringement of their works, of their pornographic images. So creating the thumbnail was a copy. It might have been altered, but it was still a copy. And they said that Google was indirectly infringing by linking to sites that were infringing by posting the entire picture. Google, importantly, did not dispute that it displayed and distributed protected derivative works. Now, derivative works is a concept that we talked about in the last seminar, but in brief, a derivative work is also an exclusive right of a copyright holder. So if you make a work that's a copy that's slightly altered, it's considered to be derivative, and the copyright holder still controls that work. So Google was saying, yeah, we infringed the copyright, right? Google admitted that a thumbnail image is derivative of the full-size image. However, Google argued that the use of the works in thumbnails was protected by the doctrine of fair use. Now, the lower court ruled against Google. The lower court said the first, second, and fourth fair use factors weigh slightly in favor of Perfect 10. The third weighs in neither party's favor. Accordingly, the court concludes that Google's creation of thumbnails of Perfect 10's copyrighted full-size images and the subsequent display of those thumbnails as Google image search results likely do not fall within the fair use exception. The court said it reaches this conclusion despite the enormous public benefit that search engines such as Google provide. Although the court is reluctant to issue a ruling that might impede the advance of internet technology, and although it is appropriate for courts to consider the immense value to the public of such technologies, the existing judicial precedents do not allow such considerations to trump a reasoned analysis of the four fair use factors. Okay, so in other words, the court said, we've looked at the fair use factors. Google searching is really important, but it doesn't allow us to circumvent fair use. However, The court did find that Google was not liable for indirect infringement because essentially the infringing websites existed before Google and would continue to exist without Google. Thus, Google was not contributing to the infringer because Google did not have any control over those websites. Google couldn't shut those websites down, and none of the profits that Google made may or may not have extracted from image searching constitutes vicarious infringement. So the court did find in favor of Google on those two instances. The court also found that an inline link is not the same as hosting content and therefore was not infringing, which is important. Now, the significance of the Google Perfect 10 case is not what the lower court said. The significance of Google Perfect 10 is because the lower court was reversed on appeal. On appeal to the Ninth Circuit overturned the district court's decision that thumbnail images were infringing. The appellate court ruled that Google's use of thumbnails was fair use, mainly because they were highly transformative. That's that first fair use factor, the nature of the copy of the work. So they said a thumbnail image is a highly transformative work. The court pointed out that Google made available to the public the new and highly beneficial function of, I think I have a quote here. Nope. All right. Of quote, improving access to pictorial information on the internet. This had the effect of recognizing that search engine technology provides an astoundingly valuable public benefit, which should not be jeopardized just because it might be used in a way that could affect somebody's sales. So in other words, on appeal, the court said, in essence, Google searching is really important. It gives people access to information. That's a very big public benefit. That should be considered as part of fair use. And additionally, a thumbnail image is highly transformative, and when it's used for that purpose, it's not actually negatively impacting anybody's sales, and it's a very different thing than the full-size image. So Google's not liable there. So in other words, Google image searching got a pass, despite the fact that image searching does involve infringing copyrights by creating derivative works. All right, well, the last big case we're going to talk about is Authors Guild v. Google. Now, Authors Guild v. Google is a very complicated case. It started in 2005, was eventually resolved in 2013. And then in between those two dates, there was a lot of procedural malarkey that we're not going to get into because it's very, very complicated. The case began in 2005 when the Authors Guild sued Google. Again, Google's always getting sued Google for digitizing books as part of the Google Book Search program, which was then called Google Print at the time. Through partnerships with university libraries, as some of you may know, Google intended to scan books, index the contents, and provide both library users and the public with the ability to search through the text of those books. The Authors Guild complained that Google was engaging in massive copyright infringement by scanning books, and also that Google would be guilty of copyright infringement by displaying the search results to book-seeking users. So in other words, I can get the content from the book by using the Google Book Search and seeing the pages that results from my searches. Now, like I said, there's years of procedural malarkey between that initial filing in 2005 and when it eventually went in front of the court in 2013 for proper argument. That procedural stuff involved mostly Google's highly criticized attempts to reach a settlement. There's a lot of problems that people were criticizing Google because they didn't like the terms of the settlement. They thought it had implications for Google's use and for financial interests on the internet and stuff like that, and freedom of information, that kind of stuff. Suffice it to say, no settlement was reached. There's also issues related to whether the Authors Guild had standing to sue on behalf of its members. So its members weren't suing, it was the organization, and they didn't hold the copyrights, right? So they're suing on behalf of copyright holders, and there's a significant question about whether you can even do that, and whether you need the actual copyright holder to bring the suit. But setting all that aside, we're going to jump ahead to 2012, when the fair use arguments were actually argued to the court. So in August 2012, much as in the Universal v. Reimers case, the EFF filed an amicus brief supporting Google's fair use defense. and it was joined by 3 associations that were representing over 100,000 libraries. The Association of Research Libraries, again, the American Library Association, and the Association of College and Research Libraries. The amicus brief pointed out several factors that favored fair use with respect to Google Book Search. Among others, I'm going to pick out a few highlights here, but among others, number one, the EFF and its other libraries argued that librarians that were surveyed about Google search said that the service can help them find valuable research sources inside their own libraries, as well as lead them to rare books they can borrow from other institutions, right? So it's important because it gives them more information about copies of books that they own and are allowed to use, right? So that's part of fair use, being able to use and manipulate your own copies of a work. And libraries in particular have their own carve-outs for lending and allowing use of their own copies of their books. Second, many librarians said that they had purchased new books for their collections after discovering them through Google Book Search. Now, this, as we've talked about, as you might guess from what we talked about, weighs in favor of the effect on the commercial value of the allegedly infringed work, or of the infringed works. So when you get to fair use, it's not the infringement. The infringement is not alleged anymore. It's happening. So in other words, what they're saying is that Google Book Search is actually leading to sales. It's not inhibiting sales. It's not frustrating the ability of authors to sell books. It's leading to more sales of those books. So it actually has a positive impact on the ability of artists to make money from their works of art. And lastly, Google Book Search is a reference tool that helps people find books and serves the public benefit. Again, all these cases end up talking about the public benefit and the benefits to society, because copyright in general is intended to benefit society, right? It's intended to promote the progress of the of science and useful arts. It's intended to improve the condition of our lives, and so we don't want to undermine that by allowing copyright law to restrict our ability to do things that have a significant public benefit, much like the parody exception allows people to make fun of public figures, right? Because it serves a significant public benefit to be able to criticize politicians, right? It's a big part of free speech. So in September of 2013, Judge Chin heard oral arguments on the case. On November 14th, 2013, he granted summary judgment in favor of Google, which is good. So Google won that case. He discussed each of the fair use factors and concluded that as a whole, Google Book Search was fair use. His remarks made it clear that copyright serves and does not impede the public interest, right? Again, that's what we've been talking about. Copyright is supposed to serve the public interest and not impede it. So what he said in part is, in my view, Google Books provides significant public benefits. It advances the progress of the arts and sciences while maintaining respectful consideration for the rights of authors and other creative individuals, and without adversely impacting the rights of copyright holders. It has become an invaluable research tool that permits students, teachers, librarians, and others to more efficiently identify and locate books. It has given scholars the ability, for the first time, to conduct full text searches of tens of millions of books. It preserves books, in particular out of print and old books that have been forgotten in the bowels of libraries, and it gives them new life. It facilitates access to books for print, disabled, and remote or underserved populations. It generates new audiences and creates new sources of income for authors and publishers. Indeed, all society benefits. So that's from the judge's opinion in that case in favor of Google. As you can see, it's right in line with what we've been talking about in terms of the purpose copyright is supposed to serve and why fair use exists and why there are those carve-outs, because the law is intended to benefit society. And it's, again, the same reason why libraries have their own particular fair use carve-outs. Now, the Authors Guild filed an appeal to the U.S. Court of Appeals of the Second Circuit, which was argued on December 3rd, 2014. In October, the Second Circuit affirmed the district court opinion. It was appealed again to the Supreme Court in 2016, but the Supreme Court turned it down, and that's it. It's done, right? So Authors Guild v. Google in 2016 was settled for good and all when the Supreme Court declined to hear the case. So decided by a lower court, affirmed on appeal, the Supreme Court declined to hear it. It's done. Google Books is fair use, which has implications for other types of library-like and book digitizing functions, which also brings us then into the case that someone asked me about at the end of the last webinar. It's a very recent case that was filed last year called Hatchett v. Internet Archive. Now, it's a pretty new case. So a few reasons why I'm not going to go into a lot of detail about it. One is because, like I said, it's fairly new. And so there hasn't been a lot of argument back and forth in the case. There hasn't been any, it hasn't really been tried to a fact finder, so it hasn't gone to a judge or a jury for a decision yet. And there hasn't been a whole lot of motion practice involved in the case that's substantive to the issues. The other reason why is because it turns out after looking into it, I know the lawyers who are working on the case, and I got in touch with them to offer my services should they be needed. Haven't been engaged yet, so I can still talk about it. But I'm not going to get into it a whole lot because I might wind up being engaged on it. Nevertheless, what happened in the Hatchett v. Internet Archive case is that the Internet Archive at the start of the pandemic, Internet Archive, those are the people who do the Wayback Machine. So what they did is they created what they called a controlled digital lending program. So they digitized a whole bunch of books, and they allowed people to access those books because they, in the interest of making sure that people had easy access to library resources when they couldn't go out of quarantine in the pandemic. Despite that, Hatchett and a bunch of other publishers got pissed off and sued them for infringement. Now, the EFF is involved in the case defending Internet Archive, and they've got some other lawyers working with them on the case. But essentially, the CDL, what it does is it allows people to check out digital copies of books for 2 weeks or less, and only permits patrons to check out as many copies of the books as the archive and its partners physically own. And that's important because that's a library exception. That's one of the fair use exceptions for a library. So a library is allowed to loan out a physical copy of its books, but they're also allowed to loan out digital copies of the physical books they own, as long as they limit it to the actual physical copies they own. So another reason why I'm not going to get into it a whole lot. There's been a lot of fervor on the internet about the case, but I don't think it's going to go anywhere because it's pretty clear to me, at any rate, that of course I'm biased, but it's pretty clear to me that the CDL is essentially a library and is subject to those fair use exceptions because the Internet Archive is pretty clearly carefully adhering to the boundaries that are imposed upon libraries. So, for example, they loan it out for 2 weeks or less. They only loan out digital copies of physical books that they own, and only so many as they actually own physical copies. So the EFF's position, which I agree with on the case, is that this is no different than traditional library lending and is covered by fair use. And I think the Internet Archive is eventually going to prevail whenever the case gets a hearing. And that's all I have. We got about 15 minutes left for questions, so I'm happy to go ahead and open it up to questions.
I just realized a typo that there. It says, please use chat function to submit. No, actually, please put them in the Q&A area, and I'll fix that for the next time. But yes, any questions?
Do my kids have any questions? I know they're probably watching this. Yes, you can type them in for the kids, right? I'm sure they really care about the fair use factors.
Well, I will throw out a question. Where do you see the future? I mean, one of the issues with the DMCA is that whole 3-year rulemaking where you can get an exception, but it goes away if you don't keep requesting it over and over. Um, do you foresee, we'll do future looking here, any copyright changes in relation to digital materials emerging in the next few years?
No, I don't think we're going to see legislation. Legislation is very difficult. Congress is pretty well gridlocked right now anyway. I think it's going to be low on anybody's list of give a crap. I think it's the kind of thing that's going to be handled in courts with case law. And most of the time, most times the DMCA has been asserted, as we saw in my discussion of these. We only talked about 3 cases, but most of the time the DMCA has been asserted or contested in court. Courts have come down in favor of fair use, generally speaking. The problems with the DMCA are mostly related to, in my opinion, are mostly related to the same kind of problems that afflicts copyright litigation in general, which is oftentimes you have people that it's too expensive to fight, right? So if you get a DMCA takedown notice, what the hell do you do, right? It could be illegitimate. It could be done for vexatious purposes. I have a buddy of mine runs a big news website in the tabletop gaming space, and he's had competitors submit vexatious DMCA takedown notices, and it can be very difficult.
We do have a question.
Sure.
I am wondering about works for hire. Do you need to have a contract that states explicitly that it is a work for hire?
No, but if you want to hire somebody, you better darn well have a contract that says work for hire in no uncertain terms. The reason why is because the case law on this work for hire issue is pretty favorable to the author and artist. So the basics of contract law, because we're getting mostly in the contract law here. The kind of basics of contract law is that you don't need to have a contract does not need to be written, unless there's a specific agreement unless it's part of the agreement, the contract has to be written. But you can make a nonverbal agreement that's binding. The problem is, how do you know what the agreement was unless you wrote it down, right? A written contract is the best way to show that at this point in time, these parties understood the agreement to mean this. We have it written down, we signed it, we both understand what these terms mean because our contract has a set of definitions, so we know exactly what those words mean in the contract when we use them, and so nobody can come back later and say, hey, I didn't understand what that meant, or I was confused, because a contract is essentially a meeting of the minds, right? When both parties understand their obligations in the agreement, a contract has been formed. So if I see somebody in the street and I say, hey, can you mow my lawn tomorrow? I'll pay you $50. He says, yeah, I'll mow your lawn. That's a contract, right? He comes, mows my lawn. Now, if you have a disagreement about that, if you only mowed half my lawn, I can say, look, why didn't you mow that half? You can say, well, I thought what you meant was the front yard, because that's what you indicated to me, right? That's why a written contract is better. And in cases where there has not been a written contract, where it's been explicitly stated that the work is a work for hire, courts have generally found in favor of the author's interpretation of that contract. Again, I'm not a lawyer, so don't take this as legal advice. But if it doesn't say work for hire in the contract, it's very likely that if there's a dispute about whether it is a work for hire, that will come down in favor of the artist.
Okay, thank you. Any other questions? While specifically not dealing with copyright, I know one of the interesting things with the difference between ownership of physical objects versus digital that a lot of times when you purchase something digitally, it actually isn't a purchase, it's a
Yeah.
license.
Uh-huh.
Um,
Yeah. That's why I own all my Switch games on disc.
yeah, and well, and with the new updated video game platforms where there are no discs, that can be a problem. I know it's been a
At some
problem
point,
with,
they could just say, no, you don't own that anymore. We're rescinding the license. Now, if any company, I haven't heard of anybody doing that, any company doing that, it would be terrible for goodwill. It would be terrible for their business. And I imagine if that was challenged in court, it could have been challenged already. I'm not aware of any case law on that point, but I expect that if it ever happened, case law would favor the consumer.
well, and I do know that in the case of Amazon, in the few instances where they've rescinded some ebooks, they've then given financial compensation, saying, hey, we're sorry we had to take this down, but here's a credit for your account.
Yeah, see, the reason why I would imagine that's going to go in favor of the consumer is because if you go in front of a judge with that kind of argument, you're dealing with somebody who owns a lot of digital licenses, right? You know, he probably has a Kindle Fire or a tablet or something like that, and has 50 audiobooks or whatever, because everybody does, right? So you're not going to be dealing with somebody who doesn't understand the situation, and I imagine it'll go in favor of the consumer owning the content or being owed compensation for the rescinding of the license, because hey, it kind of goes, it's kind of in the same vein as these issues of like, what exactly is written in these service agreements that you click agree on, you say, yeah, I read that, I agreed to those terms. Those, if I recall correctly, those kinds of service agreements can be problematic for companies to enforce. Again, because fact finders, judges, juries understand that there's a disparity in sophistication when it comes to that kind of agreement, right? And that's also kind of an important factor in copyright law, sorry, in contract law. Whereas if there's a significant disparity in the sophistication between the parties, the things are going to be weighed in favor of the less sophisticated party. In other words, you can't take advantage of me just because I'm not, I don't have a lawyer, or I don't understand what you're talking about, right? Or this was confusing to me and you wrote it in an esoteric way. Um, you know,
We actually do have a question not from me. What are the forthcoming challenges that you see with digital copyright?
I don't know. I haven't really stayed abreast of that recently. I've been, as I've been more focused on developments in patent litigation. Yeah, I can't answer that without making some stuff up. So I won't make anything up. I just say no. I don't know. The Hatchet case is the biggest thing on my radar right now.
And I haven't seen anything personally working its way up, like through the appellate system, where I'm sure Google's getting sued a bunch. Facebook is getting sued a bunch.
Yeah, probably. Yeah.
But they'll probably flag this video or something.
I normally get involved when it's people that don't have any money.
Yeah.
Because if they have money, it's probably not going to go to trial, right? If it's a copyright case.
Yeah.
They'll find something. Even Google tried to settle the Authors Guild thing. Because you just don't know, right? Copyright cases are very hard to predict. Things are a lot more, they're a lot less subjective, I'll say, and when it comes to things like patents and trademarks. Even trademarks are a lot less subjective than copyrights, because copyrights, like those 4 fair use factors, neither one of them is none of them are supposed to be more important than any other one. They all need to be taken into consideration, all four factors. So for example, like when we did a pro bono case for Games Workshop v. Chapter House Studios is one of the big cases I worked on that was tried to verdict. That was one of the first times that, I think I might have mentioned this last seminar, but that was one of the first times that that there was a strictly commercial use that was found to be fair. And the lawyers didn't want to argue it in that way. And I was like, why not? Who cares what the case law is? Make the argument, because it doesn't matter, because the first three factors strongly weigh in favor of the defendant, right? Just because the fourth factor doesn't weigh in favor of the defendant doesn't matter, because the law says that the four factors that are not individually dispositive, right? So like you can't just say, well, the fourth factor is the most important one, and because you're making money on it, or I guess it's the first factor, because it was the purpose and character of the use, not the fourth factor. Anyhow, the first factor is generally generally treated as being dispositive by a lot of judges, right? Like, well, if you're making money on it, if it's for commercial purposes, it can't be fair use, right? Except that's not what the law says. The law says that there are four factors to consider. None of them are more important than any other of them, and they have to be considered as a whole, right? You can't consider just one factor and say, I'm making my decision based on one factor. You have to consider all four factors all at once and weigh them in context of each other, right? And so one of the things we argued in that case was he's making money off of it, sure, but it has absolutely no negative effect on the value of the asserted work. In fact, it enhances the value of the asserted work, because we're talking about aftermarket accessories, right? So when you buy a product from the original manufacturer, and this guy makes an accessory, that accessory enhances the value of your work, right? Because now now there's a whole smorgasbord of accessories that you don't make, right? Because the other company didn't make the accessories at all, right? And so we argued that it actually enhances the value of the work. And the amount of substantiality taken was small, because we're talking about, again, like it was toy soldiers, right? So it's like a different door on a tank, right? Or like a shoulder pad on on armor. And so the amount that we're taking is very small. It's de minimis. Doesn't have any effect on it, right? So that's, again, why copyright cases are difficult, because they're awash in subjectivity.
Final question, and I'm just going to merge the two together because it's from the same person. There are a lot of digital books now, the ones that are just never printed. Are they also protected under copyright, and are all printed materials protected?
Well, all right, it's an interesting question. So the answer is yes and no, because copyright is very confusing. As long as it's fixed in a tangible medium of expression, the answer is yes, right? Copyright is an inherent right, which means that as soon as the work is created, it is protected. Now, it might not be protected very well, but as soon as the work is created, it's protected to a certain extent. Digital works are no different from print works. Same thing with the performance. Like if I go out and I do a dance in the street, and as long as I videotape it, I've now fixed it in a tangible medium of expression, right? So yes, digital works are protected just as much as physical works are. The complication comes in that not all works that are fixed in a tangible medium of expression are copyrighted, because copyright is limited. There's a limited period of exclusivity. So once that exclusivity expires, it is no longer protected by copyright. And copyright can be like an author can give up copyright, and it takes a specific act. Like you can't passively put something in the public domain, but I forget exactly how you do it, but you can inject the work that you make into the public domain and basically say, yes, I'm allowing this to be used for the benefit of the public, and I no longer have a copyright to it.
Kind of like a Creative Commons license.
Yeah.
And just declaring that you're free to reuse this.
Yeah. Now, the Creative Commons license is a license, right?
Yeah.
It's not.
That's the whole other thing.
Yeah, it's not technically in the public domain, because it's simply like an open license to use the copyrighted materials. Because that's another right that copyright holders have, is they can license release their various rights. But you can literally put something in the public domain. It can be kind of difficult though, again, because of the Bernie Convention. It can be kind of difficult because different countries have slightly different variations in copyright laws, and in Europe especially, there are certain things, certain rights that an author cannot give up, even under a work for hire situation, right? So in most European countries, authors can never give up the right to attribution, right? So even if it's a work for hire, the person who hired me to make it work has to identify me as the author of that work.
Okay. Well, I'm going to wrap things up. How about a nice virtual round of applause, even though we can't see it.
I'll start screen sharing.
Yeah. Oh, and can you go to the next slide?
Oh, the next one, sure. Oh, look at that.
Thank you all for joining the webinar. A link to the video recording of this webinar will be emailed to you. I believe you will also have already received a link to provide feedback about the webinar and the webinar series. You can also use the QR code, which was on the screen, or that will be, there it is in the chat box. I'm just behind today. But please do take a few minutes to complete the survey. As a reminder, we have 2 more webinars this year. Our next webinar topic will be surviving. Oh, that's not right. Will be presented by Dr. Jennifer Stevenson, and will focus on artificial intelligence and how it can be used for metadata generation. And that will be on March 25th at 4 p.m. Our final webinar this year will be presented on Earth Day, April 22nd, and focus on preparing libraries and archives for climate change. And I'll be presenting that one. Please see the link in the text for more information. Thank you very much for attending today, and have a good rest of your Saturday.